has given Trump what he wants, effectively, making it very difficult, if not impossible, for him to be tried before the election and for the American public to see all the evidence that's against him. And, I think it's important for everyone to remember that Liz Cheney, who was one of the people running the January 6th investigation in Congress, wrote a New York Times op-ed that said, look, I didn't have access to a lot of the evidence. The committee didn't, because Trump hid it from us, and we didn't have the power to enforce our subpoenas and the like. But Jack Smith does have this evidence, and a ton of evidence that the American public has never seen. And if this trial doesn't go forward because of the court's delay in answering this question, the American public may literally never see this evidence.
Everyone, thank you so much. Really appreciate your analysis and expertise. That does it for us today. For now, I'm Ana Cabrera reporting from New York. Thank you for being with us. Chris Jansing picks up our coverage right now.
Good morning. It is 11 a.m. Eastern, 8 a.m. Pacific. I am Chris Jansing in for José Díaz-Balart, and we're going to pick up with that breaking news from the U.S. Supreme Court, issuing several major decisions as its term is coming to a close, but most particularly that ruling in favor of a January 6th rioter, and another one that sweeps aside a longstanding precedent. Let me bring in NBC's Ken Delaney. And outside the U.S. Supreme Court, Barbara McQuade is a former U.S. attorney who is also an MSNBC legal analyst. Let's reset the stage here, Ken. What did the court say in its ruling in the January 6th case?
Well, Chris, before I get to that very important case, I want to say that Justice Roberts made some news by announcing that Monday will be the last day of this term. And that means we know that on Monday we will get that crucial immunity decision, the question of whether presidents are immune from prosecution in their official acts. That's the big one we've all been waiting for. It impacts the January 6th case against Donald Trump. Obviously, we now know we're getting that on Monday. But as you said, the court announced today a decision that also affects the January 6th case against Mr. Trump, although it's unclear how based on this decision. But this decision, as many expected, narrowed the scope of this law that's been used widely in January 6th prosecutions, obstruction of an official proceeding. This was a law that came out of the Enron scandal, which had to do with the destruction of documents. And one part of the law says that whoever corruptly alters, mutilates, destroys documents is guilty of this crime. And then there's an or clause, otherwise interferes with a governmental proceeding. And that second clause was used to prosecute a lot of January 6th defendants. Well, the court is now saying that that was improperly applied against Mr. Fisher and against many other people. Now, the practical implications of this are that most January 6th defendants who were charged with this crime were also charged and convicted of other crimes, including assaulting police officers. So there's only a small number of cases, 50 or so, that are going to be affected by this, and only 27 of those people are still in prison. So the impact on the January 6th case is going to be minor. In terms of the impact on Donald Trump's case, this is one of the charges levied against Mr. Trump. But many legal scholars have said that because Donald Trump's alleged plot to overturn the election involved fake electors, documents, written documents involving slates of fake electors, that conduct would be covered even under this new Supreme Court interpretation that requires this statute to be about documents. But obviously, that's something that the judge in that case and maybe perhaps appeals courts and maybe even the Supreme Court again will have to chew on. Chris,
yeah, let's pick up there if we can, Barbara, because I think even before this, the expectation was, a lot of the legal analysis was that if Fisher won, as he did, that Trump's conduct would still be covered by a kind of narrower interpretation of the law. But give us your take on the impact and how this might affect the case against Donald Trump.
Yes. So, this case is going to have a devastating impact across the country because this statute gets used in a lot of cases under a lot of circumstances. And as Justice Barrett said in her dissenting opinion, the court chooses not to read what Congress said in this statute. But nonetheless, the majority has spoken and they've decided that this relates only to documents. But the majority includes a really important sentence, which says when it talks about otherwise, it could include not just destroying, altering, or mutilating a document, but creating false evidence. And that's a really important sentence that's in there because they know what's going on in the rest of the world. And so creating a false slate of electors would still be covered by this statute. And so I see the Trump prosecution as being unchanged by this decision.
But potentially, again, I mean, look, I don't think there's anybody who's been on our air, including you, who have said they think there's another case for Donald Trump of the remaining 3 that was going to make it before the election. But does this push it off potentially even further?
Well, I don't know. I imagine that this is another issue now that will be raised in a pretrial motion by Donald Trump. However, it is not one that could allow interlocutory appeal. Even if there were a motion hearing on this issue, it would have to wait until the end of a trial before it could be appealed. I think the biggest challenge is what we hear on Monday in the immunity case. Even if we go back, Judge Chutkan has promised Donald Trump to pick up where we left off, which was 3 more months. And so I think Monday is, July 1st? Yep. That means, 3 months from July 1st, we're looking at October 1st before a trial starts. A case that's likely to go 6 weeks or more probably puts a verdict past the election, even under the best possible case scenario.
Let me go back to what Ken was saying right before we came into this hour, Barbara, which is this probably impacts maybe 50, correct me if I'm wrong, Ken, of the, what is it now, hundreds and hundreds of folks who were charged and convicted related to the January 6th insurrection. I think he said 27 of them are still in prison. This is not the first time a Supreme Court ruling obviously addresses something that has impacted previous cases. But what happens in that instance? Even if you served your time or even if you came to a plea deal, but you have a conviction on your record, can you go back and ask for it to be re-examined?
Is that for me?
I'm sorry,
yes.
Barbara.
I can answer that one if you like, Chris.
Thank you.
Or, I'm sorry, Anna. The rule is anyone in the pipeline may take benefit from a newly announced rule. So if somebody has already served their time, appeals have run, they're out of luck. They've served that. But if somebody is awaiting sentencing or is awaiting appeal, they are still in the pipeline, and so they get the benefit of that. So if someone's been convicted, it will go back either for a new sentencing if they were convicted of other counts along with this one, or if this was the only count of conviction, they could get a new trial or their case could be dismissed altogether.
Take us back, if you will, Ken, for just a minute and remind us what was at the heart of this case and what Mr. Fisher was accused of doing.
He was charged with 7 counts. This was only one of them. He was accused of violently attacking a police officer and was one of the more egregious, allegedly, members of the group of people that attacked the Capitol. So this is a significant case against him that will now go forward on these other counts, just not on this one, Chris.
Let's talk about the big other news that Ken just told us about, Barbara, which is Monday. Monday, we are finally getting, I think what most people would say, was the ruling that has been so widely waited for, and that is on presidential immunity. Again, tell us the stakes here, what the considerations are for the justices, and if you like, why you think they held it to the very end.
Well, I imagine they held it to the very end just because there was differences of opinion. I don't think they hold it for the end just for a grand finale or to stall or delay. I think it's frustrating that they did not act with greater urgency in deciding the case quickly, but I imagine there were some different opinions that had to be circulated back and forth to be able to get this decision ready. I don't think that the court is going to say everything Donald Trump did was immune from prosecution. I guess that's an example. One, to say everything is immune and the case must be dismissed. The other extreme would be saying nothing is immune and the case may proceed immediately. What I actually expect to happen is for the court to engage in some line drawing here, to be able to decide not only this case, but to give future presidents some guidance as to what kind of behavior will be immune and which can be criminal. So it could be choosing between official conduct and campaign conduct. That could be a possibility. Official conduct and personal conduct could be a possibility. And so I think they're going to draw that line. In this case, most of the conduct at issue, if not all of it, related to Donald Trump as presidential candidate and not as chief executive of the United States. I think the one area of potential disagreement is his conduct with regard to the Department of Justice and trying to use it as a way to bring credibility to claims of fraud. And so it could be that there needs to be a hearing for the lower court to address that, which then could be appealed and lead to many, many more months of appeals. So we'll have to see where it comes out. But I think the other option that Jack Smith has, if there is just a sliver of this case that is potentially immune, he could simply dismiss that conduct and move on with what he has.
Let me go back as well to NBC's Ryan Riley outside the Supreme Court. He closely follows, as anyone knows who watches MSNBC, the January 6 cases. I just want to get your take on this and the broader impact that you see as someone who has followed these individual cases so very closely, Ryan.
Yeah, I mean, it's going to involve a lot of paperwork, but I would say that I think, prosecutors were prepared for this, just given the hearing, what came out of the oral arguments, that this was sort of inevitable. In fact, just the other day, a January 6th defendant was charged, but wasn't charged with the obstruction of an official proceeding, even though under my reading of the alleged acts and, in fact, his own testimony in the case, which suggested that he was well aware of what was happening inside of the building. In normal course, you would have probably seen an obstruction charge brought against that individual, who's actually someone who hangs out outside of the D.C. jail and has harassed law enforcement officers who were testifying in other cases and was at the Capitol himself on January 6th. They didn't bring that obstruction charge in that case, which I found kind of interesting. I think that a lot of this was preparing for this potential decision that would narrow how this could be used. They could always, obviously, down the line, bring that by indictment against that individual defendant, but that wasn't a charge that they came up with up front. I think everyone's sort of been preparing for this. Defense attorneys, federal prosecutors, judges. In a lot of these cases, when judges are making these sentencings, they are saying, I would have sentenced this individual to this term regardless of what the Supreme Court did with the Fisher decision, because they were sort of anticipating this decision, which could have narrowed how this could be used. There's an individual who is actually out of jail right now, who his only felony charge, or out of prison rather right now, whose only felony charge was that obstruction of an official proceeding charge. It's an individual by the name of Larry Brock. He was actually inside of the Senate chamber. He had on this military gear, and because that was his only felony offense, and because this case was sort of pending before the Supreme Court, he ended up serving what was more than the time that he would have served just for the misdemeanor offenses. So this is basically going to end up, I think, with a lot of proceedings and a lot of different additional filings in these more than 1,400 cases that we have seen work through the system. But while there's more than 200 cases that could potentially be impacted by this, I think the practical implication is smaller, because a lot of these defendants have already served out their term. So it's not as though you can go back and get that time back, right? If you've already completed your sentence for an obstruction of an official proceeding charge, that's sort of the end of the game for you. So there are individuals who haven't served all of that out who I think will potentially be impacted by this, especially those defendants, that narrow category of defendants, about 52, who that is the only felony charge that they were facing. I think that's where this impact is